You're listening to the Max Planck Lawcast, which showcases the academic research currently being conducted across the Max Planck Law Network. I'm your host, Christopher Murphy, and together we'll be talking to some of the more than 400 researchers who are pushing the frontiers of legal knowledge in Germany and abroad. When it comes to new and exciting legal research, the Lawcast has you covered. Well, thank you very much for tuning in to the next episode of the Max Planck Lawcast. Thinking outside the box is one of those metaphors that we hear from time to time. It means to act differently, unconventionally, or to assess a situation from a new perspective. Interestingly, the German metaphor is über den Tellerrand schauen, which literally translates to looking beyond the rim of a plate. But regardless of whether we're looking outside the box or looking beyond the plate's rim, what is indisputable is that when dealing with tricky situations, it's often wise to take a step back, address the situation from a different angle, and see how others have dealt with the matter at hand. Now, you're probably asking, what does this have to do with today's episode of the Lawcast? Well, today we're going to be talking about how assisted reproductive technologies are reshaping the concept of family. But by thinking outside the box, we're actually going to be assessing the situation in two very different legal systems, namely Germany and Iran, to see how they can learn from one another by taking new approaches and leaving cultural bias behind. To do all this, I'm joined today by Najma Yassari. Najma is from the Max Planck Institute for Comparative and International Private Law in Hamburg. Najma, welcome to the program.
Hi, Chris.
Great that you were here with us today. So, I guess my first question is whether you could, for those of us, myself included, without a medical background, maybe give us a rundown of the various types of assisted reproductive technologies that are currently, I guess, in use.
Sure. So today we can see there's a wide variety of procedures available to people to conceive and carry to term a child if they themselves are biologically not able to do so. So we have this therapy for involuntary childlessness by reproductive medicine is opening new dimensions of medical responsibility. We have a shift from curative medicine to desire medicine. So for ART, for the artificial assisted reproductive technology, we distinguish between homologous and heterologous technologies. Whereas the first one, homologous assisted reproduction, uses the gametes of the couple that wants to have a child. In heterologous assisted reproduction, we have to be assisted by a third person. Either that person gives a gamete, be it a sperm or an egg, or there's a donation of embryos produced in vitro by a couple that is given to another couple.
Okay, I just wanted to, gametes there, can you give me a rundown on what you mean by that?
Oh, that indicates the sperm or the egg or the womb. That is the genetic material that you need to produce a child.
Understood.
Yeah.
Okay.
Yeah.
Okay. So we have various methods here from, I guess, back in the day with the test tube baby. There's also obviously new methods that have come about in recent years, which have kind of opened up more options for childless couples or someone seeking to have a child who can't have a child themselves to be able to have a child. Is that correct?
Yes. Yes. So generally, you would think of the spontaneous way of getting a child. Now, if one party is not able to conceive, you can address the medical centers and they will help by enhancing the quality of your own genetic material. But now today, we can also, if those genetic material cannot produce a child, we can ask a third person to donate his genetic material so that that couple can have a child.
Okay, understood. You talked there about homologous assisted reproduction, which you said was kind of the classic way that it has been done. How does law and society view homologous assisted reproduction?
Generally, because the couple who wants to conceive the child is going to stay in this unity, homologous assisted reproduction is seen as something positive that medical technologies offer to overcome infertility. And to my knowledge, there are no jurisdictions that I've studied that are against it. So generally, it is accepted of a way of conceiving a child.
Okay. And there's no religious issues here either?
Yes.
Okay. What then about heterologous assisted reproduction, where you said that we're talking about a third party being involved? How is that viewed?
So there is a saying that goes, who is the foe of love? And it is a third party. So the idea is that when a couple wants to have a child and needs another person to assist them, this is going to break up that unity that we consider to be the basic unity of society. So it has some social stigma to it. It refers to the inability of conceiving, which is seen as something that is a damage on the bodily side of a person. So it has a stigma on it. Religiously, for all the monotheistic religions, at least for Christianity and Islam, it has this idea of breaking into the holy union of two people. And immediately there are conceptions of adultery that come into that. And legally, it's also a challenge because one has to rethink the concept of filiation. So this child who has been conceived by the participation of more than two people, who is going to be the mother and who is going to be the father? So those questions are important, and thus heterologous assisted reproduction is a challenge to any jurisdiction and any society.
Okay. Well, it's good that we're going to be talking about two different jurisdictions today, namely Germany and Iran, as I said in the introduction there. Before we do that, though, I was wondering, from your perspective, what makes comparisons between two very different types of legal systems worthwhile?
So in your question, there is already the idea that Germany and Iran are very different.
Yes.
And obviously, if you look at on face value, these are very completely different countries. At the same time, I'm not interested in comparing jurisdictions on face value, but what I'm interested is how do people think about family? And if that is my question, I could actually go into any society and look for the kind of ideas and in particular discourses that are taking place in those societies about a specific subject. And so the comparison is not so much about law in the first place, but it is about attitudes. And I have done lots of field research in various countries in family law, and I've been sitting in family courts in Syria, in Iran, in Germany, in Austria. And basically what I found out is, regardless of the background of that society, it's all about two things. It's about love, it's about revenge, and it's about money. So having these similarities for everybody, I decided to look at the way German and Iranian communities, scholars, jurists, religious stakeholders talked about family and the way a family is established.
Okay. I liked what you said there about those basic values that seem to exist regardless of which society we're in. Okay, so the idea is to say, we have different societies, but they are dealing with the same issues and looking at which ways they deal with those issues, basically.
Yes, it's the idea about how do different societies look at infertility and how do they conceive, what is the theory that they use, what are the assumptions that they have about, first, is it allowed to overcome infertility? And if it is allowed, how do we account for that overcoming? And thirdly, how do we regulate then legally the new relationships that emerge from ART?
Okay. Well, then let's maybe start with Germany, seeing as we're recording in Germany today. What is allowed then as far as assisted reproduction goes in Germany?
So generally, if a couple cannot conceive, homologous procedures are allowed in Germany. So you can have intrauterine insemination, for example, or in vitro fertilization of egg and sperm of the couple. This is not problematic. And as far as heterologous procedures are concerned, in Germany, only sperm donation is allowed.
Okay.
Whereas egg donation is criminalized, as is surrogacy.
Oh, okay. That surprises me, I must say. Why is this the case in Germany?
So it surprised me too. So I went back to the times where that law, the so-called embryo protection law, was enacted in 1999 in Germany. And I read through the material, what the parliament said, what the different groups that were asked said, and in particular also what the several commissions that prepared that law during the 80s have said. And what comes out is that it seems that there is an idea that is not spelled out explicitly on the way mother and motherhood is seen in Germany as opposed to father and fatherhood.
Oh, okay.
So there is this maxim, and it is also enshrined in German law, that mother is the person who gives birth.
Right.
And this is a biological fact. On the other side, the father is always connected to the mother as her husband. So there's an assumption, there's a fiction of who's the father. So the father is the husband of the mother at the time of the birth of the child.
The father is the husband of the mother at the time of the birth of the child. Okay.
Yes.
But doesn't necessarily have to be the biological father.
No.
Okay.
So there is the Roman saying that mater certa est. So the mother is certain.
Mm-hmm.
And to that certainty, the father is linked to that certainty. Now, assisted reproduction technologies break that union of the person giving birth to a certain extent.
Yes.
Because with an egg donation, the genetic material and the person giving birth could be separated. So this was something that the authors of the law in Germany wanted to avoid at any cost.
Okay. Why was that? I mean, well, why is that? Why is this something that we have to avoid at all costs, that there's uncertainty about the mother, at least in Germany?
So what I did is, to answer that question, I read through all the papers. And what comes out, like spelled between the lines, is the idea that being a mother is something that is linked to one person only. So it is not spelled like this. What is said explicitly is that in view of the best interest of the child, it is better that the mother stays one person, because it could cause psychological problems to a child if it discovers one day, and that is a quote, that it owns its existence to the participation to its conception by two women.
Mm-hmm. Right.
And that argument is based on the argument of a mother being naturally one person. And if the unity is broken, that will cause psychological and other problems to the child. Mm-hmm. Interestingly, no such argument is made when it comes to sperm donation. So there's the idea that the father being split, or that there should be double fathers, has not even occurred to the drafters of the law and the stakeholders at the time, that could also be something that the child might have a damage from.
Yeah, absolutely. So I thought as well when you said that, it sounds a little odd that the mother, two mothers is bad, two fathers, that's okay, the child won't mind about that. It's probably too far then to say that this is discriminatory, but is there any idea around why men are allowed to then donate sperm but women are not allowed? I mean, does that all go back to this Roman maxim that the mother is always certain?
Well, what I did is I tried to analyze the discourses that they had. And it seems to me that it's not just about the mother and the father in terms of assisted reproduction technologies, but it's the idea of the mother in society as a guarantor for some kind of a nuclear bourgeois family with the values attached to it.
Okay.
So while we could say that today the discussions about the prohibition of egg donation revolve around discrimination, so the argument is, why should one be allowed whereas the other isn't allowed? Mm-hmm. And probably very soon, this is my expectation, that the prohibition on egg donation might be lifted. The argument of equality or egalitarian treatment of the gamete is not going to solve the idea that underlies it, and that is that the mother is put on a podest and she's becoming the symbol of a specific kind of family that needs to be protected.
Yes. Okay. The classic kind of nuclear family.
So the classical heterosexual conventional nuclear family. This is what the outcome of my analysis is still that what represents the value system to which the society wants to cling to, even though society has evolved.
Yes, that's right, 100%. I mean, you've basically answered my next question without even knowing it. I was going to ask you how the discussion in Germany, or this approach, has shaped the concept of family. And I guess, as you say, there, at least based on this law here, that there is a very traditional version of family has been espoused. But maybe things are going to change in the not too distant future, though, and catch up with society.
Yeah, I think the analysis shows that the concept hasn't been reshaped. It has been confirmed.
Yes, or reinforced.
It has been
That's
confirmed.
right.
Yeah, exactly. So probably this is going to change, but because it was an analysis of thoughts in the 90s. But the fact that in 2023 we still have a prohibition on the donation of egg seems that idea is still prevailing to a certain degree.
Yeah, certainly. That's right. Very interesting. I had no idea. So thank you, Najma, for that. So don't go away, though, because I'm going to be talking with Najma next about assisted reproduction in Iran and then looking at how this compares with the situation which we just discussed in Germany.
Allow us to introduce you to the wealth of information found on the Max Planck Law website. Discover a range of events, from researcher-led presentations and reading groups to workshops and conferences, many of which are open to the public. Keep up to date with our news, explore the tangible impacts of our research, and peruse Perspectives, our online publication offering insightful articles on current legal issues. And of course, for those looking to pursue a PhD or postdoctoral research, you will find everything you need to know about our many academic opportunities. Visit our website today, law.mpg.de.
Well, before the break there, Najma just explained to me what is allowed in Germany in terms of assisted reproduction. I think it's now time to flip the script and assess the situation in Iran. Najma, can you tell us what is allowed in Iran as far as assisted reproduction goes?
So in Iran, since the early 90s, fertility centers have been opened and they offer all kinds of medical procedure. And the first in vitro fertilized twin babies were born on the 29th of September in a clinic in Yazd, and the Iranian reproductive industry has skyrocketed since then.
Reproductive industry, okay.
Yeah. So there are terms that I had to learn too. And one of those terms is also a very nice term, which is fertility tourism.
Yes.
And fertility tourism points to the fact that people would travel to different countries using services of travel agencies for fertility treatment. And what we can see in Iran is that not only do Iranian couples use those centers, but there is a big market for Muslim, mostly Shia couples who come to Iran to make those therapies because for one reason, it seems to be very high standard and still less expensive than elsewhere. But also the fact that Iranian clinics are offering those procedures enhances the idea that ART is religiously permitted.
Okay.
So this all happened, the practice of ART happened in the absence of state law. So Iranian law didn't regulate any kind, neither homologous nor heterologous procedures. And what happened was that the clinics hooked up with the clerics, the Shiite clerics, and asked them to give fatwas. These are expert opinions on questions of Islamic law. And the question put to them were, what kind of procedure is allowed under Islamic law?
Okay. And they did this kind of before the industry began, or was it something that...
Well, I think it went hand in hand.
Okay. Mm-hmm.
So there was this idea, there was this technology coming in particular by Iranian doctors who had been educated in the West. They came back to Iran and sawing the market and the money that can be made with that, they hooked up with the clerics and asked for fatwas to ensure the legitimacy of their procedures. So what would happen is that the clinics would ask for the fatwas, they would print them out and put them in the halls of their clinics so that the patients could see what kind of procedure, on which basis, by which Shiite cleric had been allowed, so that they had the idea that the religious permissibility of the procedure was there.
Okay, so there was a certainty that they could go ahead with trouble occurring down the track.
Yes.
Mm-hmm. Okay. Was that a very novel approach to kind of skip the legislators and move straight to the clerics, or is this something that, happens more often than not in Iran?
So, for much of its history, Islamic law has developed outside of the state. And with the emergence of the nation state, the relationship between Islamic law and state law has been a new one, because particularly if we look at Iran, we can see that it is a country that is an Islamic republic. And according to Iranian law, in the absence of state legislation, the courts, in the application of the law, they can have recourse to the fatwas of the Shia clerics. So they have a basis of using those fatwas to have an answer to a legal question. At the same time, it was used in the application of the law, but not in the replacement of law.
Okay.
So the idea was not that fatwas should create law, but that they should step in when there's a specific demand by the courts to have a basis for adjudication. So it's a way of using these fatwas on a different level. So it's new, if you want, to answer your question. Yes, it is new.
That's right. Okay, so it was a fairly novel approach then in that case. Okay.
Yeah.
My next question then would clearly be, what did the fatwas from the clerics suggest is allowed and what's not allowed?
So we are talking about Iran, so I'm going to talk about the ways the Shia clerics in Iran have seen that. This is not the opinion of the Sunni Muslim scholars that are based mostly in the Arab world. So Iran is a specific Shia country, and the Shia clerics have taken up the ideas by the Sunni together. So the idea is, why should, in particular, heterologous procedure be forbidden? And the idea is that it will amount to adultery if you use the gametes of people who are not married to each other.
Yes.
So
that's what
in Sunni countries,
that would be
like in Egypt, in most of the countries, heterologous procedures are prohibited.
Yes.
Now, in Shia jurisprudence, the clerics are allowed to make new analyses and bring new rules based on the sources when they are faced with new technologies that demand an answer where there's no answer. So what they did is they took up the idea of adultery, in Arabic or in Farsi, it's zina, and they gave it a definition, looked at the definition, and it's the illicit corporal union, like sexual intercourse between people who are not married to each other. And they said that mixing an egg and a sperm in a test tube does not entail any corporal union. And because there is no physical union between the owner of the gametes, the mixing of the gametes in the test tube does not amount to adultery. This is one of their arguments. And the other argument is a very legalistic argument. They say that the sperm and the egg are separate legal entity. And when you mix them, they lose their specific legal status and a new entity is created. So the embryo or the fertilized egg has to be looked at legally differently as an own legal entity that can be linked to a new person. So putting an embryo into the womb of a person who hasn't given the egg and whose husband's sperm hasn't been used, so a third gamete donation, is like transferring the property of that embryo to the woman who's going to carry the child to term, and thus avoiding the idea of it being adultery.
Right. Okay. I understand that. I mean, that, as you say, is a very logical, legalistic way of breaking it down, but in many ways makes sense. What then happens, though, with, you said that we could have a mother who can't have a child naturally. She takes the sperm then from her husband, and a third party then donates an egg. They form the embryo, and then egg and sperm cease to exist once they've come together. That's right?
Yes.
Okay. How does Iran then deal with, for instance, the concept of, let's start with multiple mothers then, before we talk about multiple fathers.
Yeah. So the Shia clerics were concerned with the permissibility of the procedures, and they forwarded those arguments. They were not concerned with the idea of whose child in the first place that child is going to be. So there is a law in 2003, Iran actually enacted a law about embryo donation. And before the enactment of that law, the clerics were asked, so who's the mother and who's the father of the child? And again, in contrast to what Sunni scholars said, the Shia scholars said that, and this is quasi-unanimous between them, there are dissenting opinions, but quasi-unanimous on one point, was that according to their interpretation of a verse of the Quran, the parenthood is given to the provider of the genetic material.
Right.
So also in opposition to what German law says, it's not the person who gives birth who is the mother of a child, but the person who provided the genetic material.
Okay.
Now, if we look at if we do the same method as I did it with the German material, and to look at how do the scholars speak about motherhood and fatherhood, and what do the arguments that I found suggest, so what is read in between the lines is that they use very similar arguments than the Germans, but just for the opposing role. So what they say is, because a woman has provided the genetic material, the egg, and another one is carrying the child 9 months in her womb, both women are to have a part in the idea of being the mother of that child, because they contributed biologically to the production of that child.
Yes.
And so they award to both a certain position of motherhood, whereas the father will always remain the provider of the sperm. So if there is this concept of the husband of the mother becoming the father of the child, in ART is dismissed, and the father remains the person who gave the sperm.
Okay. Does that mean that can a sperm donation then exist, or does it exist in Iran or not?
So I'm telling you all of this. Obviously, there is a big discussion among the Shia clerics. There is not one unanimous idea of the consequences of all of this. The only idea that they share is that the provider of the genetic material is the father, right? So the idea why they do that is the same why the Germans put the mother in the first place, is that in Iranian society, it is the father who is the guarantor of the conventional heterosexual nuclear family.
I see.
So his position is more important, so he is not to be split. From him comes filiation, from him comes prestige, from him comes the respect of the position of a person in society.
Gosh, it's all coming together now. You've done it brilliant. You've given a really good explanation for that, to see why these two systems are quite different there. The same, but different in a way, I guess that probably brings me then to my final question for today, and that goes all the way back to the very start. We were talking about thinking outside the box when it comes to the concept of family in the 21st century. Based on your research, what do you think that Germany can learn from Iran and vice versa?
So what we can learn in the first place is that family law is certainly a field of law that can be studied in any jurisdiction, and any comparison can be made if we concentrate on a social phenomenon and ask our question like, how do people think of family in a certain jurisdiction? That was my first, because in the beginning I thought, well, can I compare Germany and Iran? But then when you break it down to the analysis of discourses, you can do that. And what you can see is that basically Germany and Iran are doing the same thing, but they come to different results because of the values that they attribute to certain people, the roles that they construct for mothers and fathers. So if you know that, first you can do the comparison. Second, you can relax, because you can see that the results that Germans have or Iranians have is not only the sole truth, but it reflects something, the need of a society. So if we want to change the law in Germany, and we are not going to address the role, the function, the ideas, the assumptions, the construction of motherhood in Germany, there will be still a discomfort and a disconnect between the law and the needs of the society. And the same accounts for Iran. If we are going to just stay with the father being the epicentrum of the family, we are going to discard the actually existing new families in Iran that have social parenting in it. Although the concept is not accepted, particularly the social father, it's not accepted as a concept in Iran. So I think it helps us comparativist lawyers to look at law and to understand the concept of law. And it also gives one and the other jurisdiction an option to see with the same arguments, they come to a different result. So maybe we should re-question the way we look at parenthood in our own country.
Absolutely. Very succinctly and nicely put. And Najma, I must say, I really, really enjoyed the show today with you. I've learned a lot of new insights, and it's made me also think more about both Germany and Iran, but also, yes, where do we place the mother and the father and the surrogate mother, or the surrogate father, or not the surrogate father, but the donor of sperm in the 21st century. So
Yes.
Thank you so much for being on the show with us today. I really enjoyed it. Thanks for listening to the Lawcast. If you'd like more information about Max Planck Law, or if you'd like to get involved, please visit us at law.mpg.de.
Max Planck Law. Excellence in legal research.